straight to the point. In Ghana, the judiciary, we have two levels of courts. We have the superior courts, which is made up of the Supreme Court, the Court of Appeal, and then the High Court. And then we have the lower courts, which is the Circuit Court, and then the District Court. Now, the mode of appointments for each of these courts are very different. Now, if we come to the Supreme Court, first of all, let me say that there are two important constitutional bodies that are involved in the appointment of judges to the superior courts. The Council of State, which is something like a Senate. If I may compare it to Nigeria, the system in Nigeria is like a Senate. It's a council, a constitutional body that advises the president. And then we have a Judicial Council, which is like a commission that assists the Chief Justice in running the judiciary. So it is made up of lawyers, judges, representatives of the various courts, and then ordinary Ghanaians from various sectors of national life. So these two very important constitutional bodies assist in the appointment of judges. Now, if you take the Supreme Court, and let me also say that the underlying qualification and principle for appointment of judges is that every person who seeks an appointment as a judge must be a person of high moral character and of proven integrity. High moral character and of proven integrity. So that is the basic qualification, basic requirement that the bodies look up to before you are appointed as a judge. Now, when you take the Supreme Court judges are appointed by the president, acting on the advice of the Judicial Council, and then in consultation of the Council of State. And then, after all this, you appear before Parliament for vetting. So first, the president does the appointment on the advice of the Judicial Council, and then in consultation with the Council of State, and then with approval of Parliament. So that is what goes for the Supreme Court. And any person who seeks an appointment to the Supreme Court must be about 15 years standing as a lawyer. And it can be from the bench or from the bar. There's no once you qualify as a person of a high moral character and proven integrity, you can apply or you can be appointed to the Supreme Court if the president so wish, in consultation and advice of the Judicial Council and then the Council of State, and then for Parliament. Now, the court below the Supreme Court is the Court of Appeal. And the mode of appointment of Court of Appeal judges and High Court judges are almost the same. These two courts, the members are appointed by the president, acting on the advice of the Judicial Council. This time, the Council of State does not come in, and parliamentary approval is not required. The president appoints, acting on the advice of the Judicial Council. And that is for the Court of Appeal and then the High Court. Now, a Court of Appeal, to qualify to be a Court of Appeal judge, you must be a lawyer of about 12 years standing. And to qualify for a High Court, you must be a lawyer of about 10 years standing. Court of Appeal, 12 years, and High Court, 10 years standing. But as I've indicated, the appointments are done by the president on the advice of the Judicial Council. Now, that's what happens to the Superior Court. Now, the lower courts, their appointment is very simple, but very vigorous. They are appointed by the Chief Justice on the advice of the Judicial Council and approved by the president. So you see the enormous power that our president exercises in judicial appointments. Even at the lower courts, every circuit judge or district magistrate may be appointed by the Chief Justice on the advice of the Judicial Council, but the president has to approve the appointment. And so that is the position that we have. And the circuit judge, you need to be about 5 years standing at the bar, and then the district court magistrate, you need to be about 3 years standing at the bar. So basically, the lower courts, even though the Council of State does not come in and they don't go for vetting. In fact, there's a vigorous background check by the security agencies to try and find out whether the person meets the standard, that is a high moral character or proven integrity. So they go through that vigorous background check. And then after they have gone through that, those who are selected, they write exam, a competitive exam. And then after, if you are successful, they are interviewed before they are formally appointed onto the bench. So basically, this is how our structure is. And this is how appointments are made to the bench. And as I said, appointment can be made directly from the bar, and appointment can also be made in the form of promotion on the bench. For example, from a circuit court to the high court, or a district magistrate to the circuit court, a high court to court of appeal. And once you are going to the next level of the court, the procedure for appointment must be satisfied. So for example, if a court of appeal judge is nominated for the Supreme Court, the court of appeal judge, the appointment must be, the president must consult the Council of State, must consult the Judicial Council, and then also that judge will have to appear before Parliament for vetting. So basically, my brothers and sisters, this is the appointment procedure in Ghana. It is all centered around the president, but acting in consultation or advice of the Council of State, which is a constitutional body, and then the Judicial Council, which is also a constitutional body established under our Constitution. Let me also say that the removal of judges is now also very strict. There are only 3 grounds for which a judge can be removed. A judge can only be removed on stated misbehavior. So the ground was a stated misbehavior or incompetence. And then the last one, where the judge's inability to perform the function of his office. These are the only 3 grounds upon which a judge can be removed. And these are constitutional requirements, constitutional provisions. They are all entrenched provisions in the Constitution. I believe it is because of where we came from. You know, during the First Republic, under the President Nkrumah, some judges were removed. When they delivered a judgment that did not go well with the president, they were removed over the radio. And since that time, all the subsequent constitutions have made it, had tried to entrench and then secure the tenure of judges to ensure that there's some independence and that the president will not have his whims to remove judges at his beck and call. So basically, and in a summary, I think this is what I want to share. The significant thing is that the Attorney General of the country plays a role in all these appointments because he representing the government. They can bring names, they can nominate names to be considered by the Judicial Council and then the Council of State. And then if such a person is approved by the Judicial Council and the Council of State, then the president will forward the name to Parliament regard to Supreme Court appointment. Then the Parliament will vet the person. And if the person is given the green light, then he will be sworn in as a panel, a member of the Supreme Court bench.
Thank you
now,
very much.
the Chief Justice himself
Thank you.
or herself. Okay. So thank you very much.